Wallin, here with partner Matt Wallin of Wallin and Klarich. And today's topic is one that has been very, very interestingly put in the news because of O.J. Simpson's recent being paroled from prison. Because what it brings back is the case where he was accused of killing his wife and another gentleman. And the overwhelming sentiment of society back then was that he was guilty of 2 heinous murders, and he put together $1 million dream team, and he was found not guilty. The question we have received for years, decades of practicing criminal defense is, how can you represent people who do such horrible things? And I'm here with Matt to talk about that issue and why it is easy for us to represent people who are accused of serious crimes. Matt, why don't you talk to us about the difference between legal guilt and factual guilt?
Yeah, I think the most common misperception in the public is that, A, we know for certain whether our client's guilty or not. It's not for us to determine our client's guilt. Obviously, that's for a jury to determine. So when a client comes and sees us, and he comes to our office, although on the surface it may seem as if they've done something wrong or illegal, whether or not they're going to be proven guilty beyond a reasonable doubt is a whole different story. So our job really begins when they're quote-unquote guilty. So it's easy for me as a defense advocate to represent people accused of crimes, irrespective of my own personal belief about their guilt or innocence.
But what happens in a case where a person comes in and he's been arrested and you go see him in the jail and the person makes statements to you indicating that he is guilty, at least of something?
Yeah, that's the norm. I would say the vast majority of cases, my client is guilty of something. The issue is whether or not the evidence that's compiled by the state is sufficient to prove the charge for which they're charged with. Oftentimes, someone makes a poor decision and they've committed some crime, perhaps not the crime they're accused of. And even if they have, just because they're quote-unquote guilty, it's really where my job begins, not ends, in terms of mitigating the punishment and the sentence, etc.
Well, let's talk about that. So, for example, let's say someone you meet with is accused of murder, and he wants a good lawyer. Why is it important when someone is guilty of a crime like that to have a good lawyer? How can it make a difference?
It's counterintuitive. So when someone's accused of committing murder, most people think that it's the person who is innocent and needs a lawyer the most. The person who's clearly quote-unquote guilty needs a lawyer to mitigate the impact. Maybe they're facing 10 to 30 years in prison, and our job is to get them evaluated psychologically or get references or build up their character in order to get them a just outcome in the case. So whether your attorney is fighting the facts and the evidence or fighting the sentence, either way you need to have an advocate by your side. That's what we do.
Okay. Another thing that comes up sometimes in these cases is when you first interview a defendant and he might make statements to you that indicate he's probably guilty, but later on the eve of trial, he says, no, I'm not guilty, I didn't do it. Are you still able then to represent him and have him go on the stand?
Absolutely. It's a perfect example of there's many motivations behind why a defendant or client might profess their guilt to you, and that changes oftentimes. So what's important is, of course, we can't promote perjury before the court, but we have to go off of our client's word. And if our client has told us at the last moment that they're, quote, not guilty, or told us a certain state of facts, we're allowed to question them about that and proceed on that.
And something that's very interesting that I want to add is we've been doing criminal defense for over 35 years, and we have very good criminal defense lawyers. And sometimes we'll have meetings, and one of our lawyers will say, well, how can I put him on the stand because I think he did it? And I say, were you there at the scene of the crime? And of course the lawyer wasn't, and I say there are only 2 people that know if the crime occurred or not. Say if it's a sexual assault, the alleged victim and the defendant. And if you believe in God, a third person. So it is not our job as criminal defense attorneys to judge our client guilty. In fact, that's the prosecution's job. So we must believe what our clients say and zealously represent him. Another thing that's commonly misunderstood is that there's more than one victim in one of these cases. Because the defendant is accused of a crime, and of course there's the alleged victim and their family, and then there's the entire family of the defendant who we have to confer with because they obviously are also victims in these kind of cases. So do you believe that it's even more important to have a excellent, experienced criminal lawyer if someone is technically guilty than even if they say they're not guilty?
I think in both respects, I can't say which one more or less, but they both have the need for an attorney. It's just the attorney's role changes a bit. But what's for certain is it's not for the attorney to determine guilt or innocence or whether the client's guilty or not guilty. We just have to advocate for them based upon the state of the facts.
And the last thing I want to say today is that for 35 years, you meet people at parties, at social events, in court, and people look at you askance and they say, how can you represent that person? He's facing such a serious charge. And it's often those same people that come to us for legal help when their son or daughter or themselves is accused of a crime. And I never remind them that they made such a statement, but I also never forget it. So understand, if you're facing criminal charges, if you need legal advice, we're here. Call us anytime. It's free to talk about your case, and we'll see you next week. Thanks, Matt.